Hi, I'm Tim Meyer, and I'm a member of the Board of Editors of the American Journal of International Law. I work on public international law issues, and I have a particular interest in international trade law and its connection to environmental law. This video is part of a series that we are calling AJIL Bookmarked, in which editorial board members are delving into AJIL's back catalog to bookmark articles for rereading. I've been looking back at AJIL issues from the 1970s, and in this video, I'm going to talk about the piece that I bookmarked from that decade. I've chosen the Jurisprudence of International Trade, the Disk Case in GATT by John Jackson that was published in AJIL Volume 72 in 1978. All too often, international rules are drafted with little sensitivity to their total context. Indeed, there is a certain naivete about the viability of rules. The naivete at the international level extends to reliance on false analogies between national legal rules and international legal rules. National court techniques of interpretation or construction, for example, may not apply in the international consideration of a similar problem. The degree to which courts will be trusted, and thus the leeway for creative interpretation, is likely to be quite different in a national setting from that of an international setting. The perception of a rule as an ethical goal, as opposed to a pragmatic description of consequences, the ought versus the is, will differ substantially in the two contexts. I picked this article because it shows Jackson thinking through issues in the 1970s in the context of the General Agreement on Tariffs and Trade, or GATT, that many thought had been left behind with the creation of the World Trade Organization, or WTO, in 1995. But these issues have reemerged with a vengeance in recent years. Jackson's article grapples with the proper role of panelists on international tribunals and the tension between negotiated rulemaking among nations and gap filling by international tribunals through adjudication. Moreover, he does so in the context of a case about state subsidies, the government policy tool that is today central to the tension between the world's largest economies. Absolutely. Later in the piece, Jackson writes that the critical question is where and how to draw the line between hundreds of governmental measures, often taken for legitimate domestic policy reasons, and those measures which are deemed to be so predatory in nature that the international trading system cannot tolerate them. Government officials, trade lawyers, and scholars are grappling with exactly that question on an almost daily basis. Some of the issues are similar to the specific cases Jackson was concerned with, for example, widespread subsidies for industry in China or subsidies for Boeing and Airbus in the United States and the EU. Other issues, such as carbon tariffs or border adjustments as they're known, or the increased concern with labor standards overseas, are newer. But the central question is the same one that Jackson confronted: how to balance an individual nation's right to regulate with nations' collective interests in an open global economy. Today, the future of WTO dispute settlement is in doubt. The WTO's dispute settlement body, which John Jackson played a seminal role in designing, has arguably been the most effective international dispute resolution system ever created. Yet it's fallen prey to exactly the kinds of concerns that Jackson identified in 1978. The United States accused the WTO's appellate body of acting like a domestic court and substituting its own creative interpretations, as Jackson put it, for the substantive rules on which nations feel they agreed. Moreover, the United States' decision to paralyze the WTO's appellate body has turned WTO dispute settlement into a system that more closely resembles the GATT system about which Jackson was writing. In that system, as today without a functional appellate body, it is possible for nations to block the adoption of a legal ruling against them. That possibility elevates the role of diplomacy and of states themselves in interpreting and applying international rules at the expense of international tribunals. Most importantly, though, Jackson's piece reminds us that there's nothing new under the sun. We've been faced before with different versions of the same problems confronting the global trading system today. Those lessons from the past may offer us insight into how to address the problems of the present. We hope that you enjoyed this brief look back through the AJIL archives, and I hope that it inspires you to bookmark your own discoveries from the journal's pages.